Just a warning before we begin, the following segment contains content that some viewers may find distressing. Viewer discretion is advised. Welcome back everyone to Frontlines and Faultlines with Mike Kelly. We'll be concluding our series covering off on the laws of armed conflict today in relation to the war in Gaza. And you recall last time that we finished up talking about the medical situation and the facilities issues in the Gaza Strip during this war. Might also add to that we've talked a bit about the misfires of the thousands of Hamas and Palestinian Islamic Jihad rockets. That has been evident quite significantly in this conflict. Well, one of the situations that we saw occur was a misfire that hit the Al Ali hospital early on, originally attributed to Israel, but very conclusively demonstrated to be one of these misfires causing large-scale casualties for the Gazans who were sheltering near the hospital. So these are the things that really require you to sit back and carefully look at and analyse events as they occur and not respond or make judgments quickly. And we'll look at another couple of incidences along those lines. But one of the other issues we've seen is this debate about casualties, and you'll regularly see media outlets talk about 50,000 people killed. They give the impression that that's been 50,000 civilians. No outlet that I've watched ever attempts to break down how many figures relate to the combatants in this conflict on the Hamas and Palestinian Islamic Jihad side. It's somehow miraculous that we haven't seen the report of any casualties from Hamas, as if they haven't had any. And of course, we know that the IDF has suffered 408 killed in action and growing, and at least 5,780 wounded in action, and that climbs almost every day. These people did not choke on their ration packs. They've been killed in fighting against Hamas. So it's been incredibly disingenuous, and BBC has even admitted at times that, yes, they haven't broken down those statistics to include, who are the combatants and who are civilians. We know for a fact that there were 1,200 Israelis killed on the invasion that happened on the 7th of October. We've had probably about 20,000 Hamas and Islamic Jihad unlawful combatants killed during this war. And now several thousand, of course, have been taken prisoner. And it's important to note, too, that what the Hamas health announcements have included is the natural deaths that occur in Gaza. And in any given year, you will have around 5,000 natural deaths occurring in the population of 2 million. As we know, and so they've included natural deaths in their figures. But even lately, they've been admitting that their figures were wrong and exaggerated and incorrect in the construct that they've tried to put forward, and we'll come back to that in a second. But it is important to note that there is no health ministry as such in the Gaza Strip. It is all part of the Hamas operation, and it's central to the Hamas propaganda operation. As a terrorist organization, it's a significant line of operation to really prioritize that propaganda effort, particularly if you're creating asymmetric warfare. You're trying to undermine support for your opponent and trying to paint them in a particular light. So there is no health ministry. It is Hamas who are giving you their statistics on casualties. So we talked about the misfire at the Al Ali hospital, but there have been 32,000 rockets and missiles fired against Israel in this current war alone. And if 20% or 10 to 20% of those fail, then you can see exactly what the consequence is going to be for Gazan civilians. So probably about 2,000 killed from rocket misfires in this war alone. So 5,000 natural deaths, 2,000 casualties from their own misfires, and 20,000 combatants, unlawful combatants killed has to be factored into any look at these statistics. But also there was a claim that 70% of the casualties were women and children, and it's now been clearly established that 72% of the fatalities were between the ages of 13 and 55 men. And this is the demographic category that aligns with the Hamas combatants, and I'm not saying that all of those 72% were Hamas combatants. Clearly, some of those will have been, or a number of them will have been civilians, but clearly that scale, that level of casualty relates to the fact of what we're talking about in terms of Hamas fighters here. So these are the facts that are starting to emerge, and we've had an analysis done of these by the Henry Jackson Society, which has broken down some of the misinformation and lies that have been perpetrated. And of course, some of these issues have been, apart from artificially inflating the women and children and natural deaths, it's now updated their statistics by removing 3,400 deaths that didn't actually happen. So, that's what they're admitting to. And during the course of the war too, you've seen the announcements that were made early on in the piece were this perfect linear trajectory, which never happens in war. You will have significant variations from day to day, but basically, effectively, they applied a formula of how they were going to claim casualties, and it was this perfect linear growth, which has been absolutely discredited through statistical analysis. And we even saw the Lancet Health Journal claiming that 189,000 civilians had been killed, which even Hamas wasn't claiming. And they mainly based that analysis or assessment on the fact that if you see these numbers of buildings destroyed and you think that there may be this number of residents, then that's how many people must have been killed. And completely spurious analysis, because it didn't take into account the extensive efforts that Israel has made to get civilians out of the way of their actions. And when we talk about precautions in attack, the extent to which the IDF and Israel acted in this war is unprecedented and never been seen before. The extent of their precautions have included sending text messages, dropping leaflets, emails, making announcements publicly, and designating areas for people to move to. All, of course, being driven by the fact that Egypt won't open up, or wasn't offering to open up the Rafah crossing to allow civilians to take shelter right out of the way of the ongoing military operations. So they had to be moved around within the Gaza Strip. But that's what happened, and that really helped to minimize civilian casualties. And even then, Hamas, deliberately tried to compromise zones that were set aside to be safe zones for civilians by continuing to conduct rocket launches, etc., and activities and operations from those safe areas the Israelis were trying to designate. So, what we have seen is this outright manipulation of the situation by Hamas, and it also extended to the level of them shooting and killing many Gazan civilians who were attempting to move and comply with Israeli directions. They attempted to stop the civilians from leaving those areas and really eliminating their civilian shield, in effect. So a lot of the casualties that we've seen happen have been caused deliberately and intentionally by Hamas themselves, including their shooting of civilians who are attempting to take advantage of relief activities. A large part of the relief delivery that's happened in Gaza was being looted and taken over by Hamas, either to stockpile for their own uses in their fight, but also to be used as part of their financial operations as well, to sell this food on the black market and whatnot. So that's the reality of the casualty figure situation. Now, very quickly, I want to go through a good example of people making rush to judgment. So we'll all know about the special advisor that was appointed to look into the World Central Kitchen incident, where an Australian citizen was actually killed and involved an Israeli strike on a couple of these World Central Kitchen vehicles. Now, Mark Binskin, who is a former chief of the Defence Force and many, many decades in the Air Force, was involved in targeting processes in the Iraq War in 2003, but also led the Defence Force during its operations in Mosul. Very familiar with the problems of urban warfare and targeting processes. So he looked into this situation on behalf of the government, and these are the important things to note about his report. So firstly, he, in his analysis and a deep dive on IDF targeting processes and command and control arrangements, said that basically they have the same type of approach, the same type of structures and authorities that exist for the ADF, and the sort of things that we would also be concerned with in a situation like this. So very similar approach to how the ADF would be dealing with an urban war situation like this and targeting, and the criteria identification processes, etc. So he also noted that the IDF's view of the rules of engagement, which are the specific rules you give to troops, translating laws of armed conflict and other limitations that will be placed on them, very, very similar to the Australian situation, and the standing operating procedures in relation to decisions on targeting, and the delegations in relation to those, very similar to the ADF's. And so when he talked about the specific incident, he basically said too that the targeting rules and control mechanisms would have been the same or similar to what Australia would have had in place in a similar environment. And the investigation system that the IDF has, he says, is similar to the Australian system, but in fact it is vastly superior, because some of the critical elements, and it's important to note that there are two dimensions to that IDF and Israeli investigation process to incidents. One relates to an operational analysis to what mistakes may have been made from a targeting command and control point of view, what are the lessons learned from that. But there's also an independent investigation process that will relate to surfacing whether there have been any criminal responsibility issues emerging from that. And it's entirely separate from the military command structure. We'll look at that in a minute. So in relation to the independence structure that applies to this, the military advocate general in the IDF is different from the military legal structure in the Australian Defence Force. Military legal officers are still part of the command and control structure of the ADF. But in the IDF structure, those officers remain independent of that command structure. And the military advocate general has statutory independence via the Military Law Act. It's a ministerial appointment. It has immunity from the chain of command on all professional matters, and a legal obligation that requires IDF commanders to follow the military advocate general and her core officers instead of the other way around, and they have to follow their legal advice. And the supervision of the military advocate general is purely civil. It comes from the Attorney General and Supreme Court of Israel. So that's actually superior to the structure that exists for the ADF. So Mark, in his report, and we'll be interviewing Mark later in this series to talk about his experience of targeting, but he did mention the fact that the World Central Kitchen trucks moved away from the Welcome Centre and the area that they'd discussed and had approved in terms of the routes they were going to be using on that day. They weren't meant to be moving at night, and in particular they weren't meant to be having armed security guards. So they went in the face of IDF requirements in relation to NGOs operating in the Gaza Strip in that respect. And one of the problems that then occurred from them having those security guards is that they were observed to be firing into the air, very much like Hamas was doing in relation to looting and driving off Gazans from the relief materials. And this was vision that was being obtained at night as well. So there's some things you can see clearly and obviously from night vision, but other things are not so obvious, such as markings on vehicles of the kind that the World Central Kitchen had. And I served with the International Committee of the Red Cross on secondment in Bosnia, and you can't compare the way those two organisations, the World Central Kitchen and ICRC, operate. You look at an ICRC vehicle, you'll see great lengths gone to, including mounted flags, and great lengths gone to in terms of the communications capabilities in the vehicles and their requirements to remain in contact with a central communications framework, and then constant communication between the ICRC and any armed force or organisation that are in the vicinity or dealing with the overall control of the environment they're in. So the situation that was coming from the observation through the UAVs was very much consistent with the way they'd seen Hamas operate in relation to hijacking aid convoys. So the Coordination Liaison Administration, the CLA, which is the Israeli mechanism that helps manage the NGO presence and the relief activities in Gaza, they made very clear to Mark that armed guards on humanitarian aid convoys that are fully coordinated with the IDF is unusual, and if in this case, if it had been requested by World Central Kitchen, it would have been denied. So this was a big failing on the part of the World Central Kitchen administration. And so Mark said that based on the information available to him, his assessment was that the IDF strike on the aid workers was not knowingly or deliberately directed against them. So this also played out in the comment that he made, that he can't rule out that the World Central Kitchen inadvertently contracted security for the aid convoy with an entity that had links to Hamas as well. So there was a confluence of things going on in relation to this incident, but it was the impression that was given by the comments of the Foreign Minister, Penny Wong, that this was not an unintentional attack is incorrect. Mark Binskin's report was very clear when he said that it wasn't intentional, not deliberately directed against the World Central Kitchen. Now, Mark also highlighted that the Brigade Fire Support Commander who guided the strikes was dismissed from his position. The Chief of Staff, Reserve Colonel, was dismissed from his position. The Brigade Commander was formally reprimanded. The Division Commander was reprimanded. And the IDF Southern Command Commander was formally reprimanded as well. So these were all administrative steps that were taken against these officers, very senior officers. And that's basically because of the failure to apply some of their operational guidelines and requirements. And you have a large number of officers who are rotating through the Gaza Strip who are reservists. And obviously there's a failing in keeping them fully briefed and up to date on formal processes that needed to be applied. So there was a failure in some steps in relation to this, and there was a failure of the ability to communicate with World Central Kitchen directly on the ground. They had to actually try and go back through World Central Kitchen headquarters in the United States to try and deal with the situation. That obviously was unsuccessful and unacceptable. So, but what he said about this was that it's not dissimilar to situations that have happened in other places that we've been operating in too, such as in the attack in Afghanistan on the Kunduz hospital. There was an MSF hospital there that the United States accidentally targeted and destroyed the hospital, and there were a large number of casualties. So it was assessed, though, that it was a mistake, so it's not criminally a culpable act. And come back to these points we've highlighted, that there has to be intentionality for things to be a war crime. So it didn't meet the requirements for a charge of unlawful killing, and sanctions again were applied to administrative and disciplinary measures taken, and suspension and removal from command, etc., letters of reprimand. So this is a fairly standard approach that Western militaries will take. For mistakes that are made operationally, maybe a standard procedure on targeting not adhered to, but not amounting to a violation of the laws of armed conflict or a war crime. So he surfaced this in his report. That Kunduz hospital attack was done by a US Air Force AC-130U, a gunship. It attacked the Kunduz Trauma Center, and there were 42 people killed and over 30 injured. So just to highlight that sometimes quite serious incidents occur. Nothing on the scale of, obviously that happened in Gaza. there was a couple of people killed in that mistake. It's tragic, nevertheless, but a mistake. So I mentioned the Henry Jackson Society's detailed study on the casualties, really trying to get to the bottom of what Hamas was talking about or trying to convey, or the propaganda. And the detailed analysis I'd recommend to people to read. But basically, we've sort of surfaced through that report a lot of the things we've highlighted from other sources as well more recently. But basically, the fatality reports from previous conflicts that the Ministry of Health have engaged in reveal evidence, in this case, of attempt to hide militant fatalities, and also identify critical differences in demographic breakdowns reported by the Ministry of Health and the Hamas government media office. So they surfaced a lot of discrepancies in the way things were being even reported by these agencies on the ground. So now I want to come to the Genocide Convention to really zero in on finishing off this conversation. It's important, as I mentioned, to read not only conventions and what you see in them, but the deep background to them, the travaux preparatoires. And in relation to the Genocide Convention, this is one of the most critical statements that were made in that preparatory work, and this is required reference to interpret the treaty. I'll emphasize that. So what the convention, the process that the preparatory work specified in that was that the infliction of losses, even heavy losses, on the civilian population in the course of operations doesn't, as a rule, constitute genocide. So in modern war, belligerents normally destroy factories, means of communication, public buildings, etc., and the civilian population inevitably suffers more or less severe losses. Now, remember, they're just coming off the experience of World War II, and they have that reference point in making these comments. And they state that it would, of course, be desirable to limit such losses. Various measures might be taken to achieve this end. We're talking about precautions in attack, etc. But this question belongs to the field of the regulation of the conditions of war, in other words, the laws of armed conflict, and not to that of genocide, the Genocide Convention. This is very important to understand. And the crime itself also carries a really specific type of intent, what they call a dollar specialis, specific intent, very hard to establish. There are all sorts of tests that need to apply to that, and we might talk more about that with Professor Tim McCormack. But it's quite instructive to read some of the separate judicial statements that were made in the original ICJ processes, International Court of Justice processes, in relation to the South African allegation against Israel of genocide. And this is really the essential point. It comes back to what I talk about of trying to shoehorn tough political situations into international law, or the law of armed conflict, or in this case, genocide. And she stated, really, Beld-the-Cat here, is strongly of the view that the controversy or dispute between the State of Israel and the people of Palestine is essentially and historically a political or territorial one. And she says perhaps ideological as well. And she's giving a signal there to the Hamas and Islamist extremist absolutist objectives of destroying the state. So she's basically said that this calls for not only a diplomatic or negotiated settlement, but the implementation in good faith of all Security Council resolutions by all parties concerned, and particularly in some of those they refer to the need to resort to peaceful means and peaceful methods and negotiation, which has been rejected time after time by various opponents of Israel in this process, with a view to finding a permanent solution whereby the Israeli and Palestinian peoples can peacefully coexist. So basically, get back to the negotiating table and dispute resolution, not try and use, the International Court of Justice to achieve that result. It won't be produced by the judges sitting at the ICJ, is what she's saying. And this is the clearest, most obvious statement I've seen yet in relation to this process that's engaged at the moment. And she says, look, that's the failure of states to really get serious about this and the problems and the controversies and get a diplomatic framework happening on a concerted basis and concessions that need to be made. And yes, concessions need to be made on both the Israeli side and Palestinian side here. But she's saying that effectively it's going to lead to this resort to pretextual invocations of treaties like the Genocide Convention when you prevent, deny, or don't participate in good faith in those diplomatic processes. And that's a desperate bid, as she's described it, to force a case into the context of such a treaty in order to foster its judicial settlement, rather like the proverbial Cinderella's glass slipper. So I fully endorse what Judge Sebatinda said. And it's also very important to understand what happened, and we'll get Tim McCormack to explain the processes of the ICJ. But there's been one claim in particular that's been heinously manipulated and perpetuated in the media and elsewhere, that the court decided that there was a plausible genocide. So let's have a listen to the president of the International Court of Justice at the time, Judge Joan Donoghue, who was sitting in that process and who participated in framing the orders and the decisions that happened after it. So let's have a listen to what she has to say.
Would it be fair to say, and I'm no lawyer, and many people watching and listening will not be lawyers, but would it be fair to say that the key point that you made your initial order and ruling upon was whether or not there was a plausible case that should be taken on by the court of genocide in the case of Israel's actions in Gaza after October 7, and you quite clearly decided that there was a plausible case? Is it right to say that's at the heart of what you decided?
I'm glad I have a chance to address that, because the court's test for deciding whether to impose measures uses the idea of plausibility, but the test is the plausibility of the rights that are asserted by the applicant, in this case, South Africa. So the court decided that the Palestinians had a plausible right to be protected from genocide, and that South Africa had the right to present that claim in the court. It then looked at the facts as well, but it did not decide, and this is something where I'm correcting what's often said in the media, it didn't decide that the claim of genocide was plausible. It did emphasize in the order that there was a risk of irreparable harm to the Palestinian right to be protected from genocide. But the shorthand that often appears, which is that there's a plausible case of genocide, isn't what the court decided.
Okay, so that should clear it up for anybody who's willing to actually listen to the truth from Joan Donoghue, or actually go ahead and go back and read the document itself, which I've done, and I've read all the separate judgments. So that part of the process, it wasn't really dealing with the substantive issue, and we'll come back and talk about that more on a later date. So, precautions in attack, the Binskin report talked a lot about those that the IDF has in place, but we talked about the evacuation process and all these means by which they warn the population, but they've also adopted these techniques of roof knocking, so-called, where you drop something substantial but not an explosive ordnance or rocket or missile to basically create a noise in a building to send the signal that that building is now going to be targeted if the message didn't get through from any other means. So it's a non-lethal item and meant to kind of send a warning. So all of these things, a lot of them have been innovations by the IDF, never been used before by Western or other militaries in trying to expand the options for precautions in attack to minimise civilian casualties. And the approval process that Binskin described is quite extensive in relation to decisions on targeting at the end, where they're not complied with, they'll be dealt with from a disciplinary point of view, but they go beyond the laws of armed conflict. So then we come to this final issue that I want to raise, and we'll talk more about this with Professor Tim McCormack, but we've seen these International Criminal Court warrants issued against officials in Israel at the political level, the Prime Minister and the Minister for Defence, alleging war crimes. It's an allegation and there are only warrants at this stage, but it's very important to understand the principle of complementarity that underpins the Rome Statute and the International Criminal Court. And we'll get Professor McCormack to explain that complementarity element, but basically what it says is if you've got a state that's got a structure and a system, you've got to give it a chance to deal with its own issues, and you can't just jump in and circumvent that. And they were invited to come to Israel by the Israeli government to get a deep brief on all of those processes, and they were due to go to Israel in May of last year to get that briefing, and then these officials of the International Criminal Court, including the prosecutor, but reneged on that visit and didn't come, and haven't sat down with the Israeli government or authorities to even understand properly what processes are in train and in place there. So that decision to step forward and go ahead with the warrants was actually reversed in that November 2024 order just on the 24th of April, only just very recently, by the appeal chamber at the ICC. So that will now go back to the lower court for assessment of Israel's jurisdictional objections, coming back to this complementarity principle in the original issue of those war crimes. So that issue is still before the courts and hasn't been resolved yet, thanks to the successful appeal against the issue of those warrants by Israel. So that fight's going to go back to the lower court, and we'll see what will emerge from that. So, I mentioned the investigative structure that Israel has, but it includes not only that military criminal process and analysis, but the operational one. So they have this operational fact-finding mechanism, and they have around 350 active probes into the operational methods and techniques and procedures, etc., that are being applied in Gaza. So there's 350 investigations into that system and to see what success or failures have been there, and they have about 1,000 more preliminary probes into the war going on as well, into various incidents and allegations of misbehaviour or even war crimes. So those investigations are taking place. A very thoroughgoing process it is too. And in Western processes, those things take time. We've just seen now, quite a few allegations being made against Australians from the war in Afghanistan. And the first case of all that list of allegations is just only recently gone to court. It involves Trooper Oliver Schultz, who's innocent until proven guilty. So this process is ongoing, and no one should make any prejudgments of it. But it relates to an incident that was alleged to have happened on the 28th of May, 2012, and that trial only just began on the 7th of April this year. It's taken 13 years to get to this point. So sometimes you have to exert patience when you're looking at these things, and judgments have to be delayed until those proper processes have been fully entered into and finalised. I'll just finish off by saying one thing and making this emphasis. In my mind, and I think to most reasonable people, every single civilian death is one too many. Unfortunately, urban war is the most casualty-intensive form of fighting. We've seen that illustrated and demonstrated multiple times throughout history. My conclusion from this is don't start wars. Hamas, Iran, and all their galaxy of aggressive Islamist extremists and terrorists should never have started this war. The bottom line is, now that it has been started, we've got to finish it in a way that gives us the opportunity to eliminate these threats and this ideology as far as it's possible to do. War of aggressions, I will emphasise throughout all of this, are a war crime. It's the fundamental start point for everything else that we talk about. So look, that's a basic rundown on all of the international laws of armed conflict and relevant elements to assessing this current situation. It doesn't deal with the broader issues that we can discuss at a later date about the overall peace processes and issues around the West Bank, etc. And we'll come back and talk about those at another time. But for now, we'll leave our discussions there, and I look forward to coming back and talking to you next week on some more issues that are emerging in our world at the moment and unpicking them and trying to make sense of them. So thanks for being with me. I appreciate your patience and look forward to talking to you next week. Cheers.